І я із задоволенням надаю слово нашому колезі із Канади Дональду Чіассону, директору правових та освітніх питань Групи міжнародного співробітництва Національного суддівського інституту Канади для доповіді по темі «Прецедентні та модельні рішення. Погляд з Канади». Це, скажімо, ця доповідь стала можливою завдяки участі у нашому форумі канадського проєкту підтримки судової реформи в Україні. Ми дуже вдячні цьому проєкту і з задоволенням послухаємо пана Чіассона.
Thank you very much for this invitation to speak here today. The topic is Western traditions in post-Soviet countries, such as Ukraine. And there are, of course, two major Western traditions. One is the civil law tradition, and the other is the common law tradition. And I, with no surprise, I'm going to talk a bit about the common law tradition. Ukraine appropriately sees the European civilian continental model as the model which it will follow, and that is as it should be, and I could not agree more with Professor Solomonov that transplants of foreign law just don't work, generally speaking. Nonetheless, in these circumstances, I believe there are some common law traditions and features that may have some usefulness in the reform transition here in Ukraine and generally. It's been noted, and it's almost trite to say, that civil law and common law systems have increasingly borrowed from each other, and so too in Ukraine. The Criminal Procedure Code is one of those examples. So this will be a bit of a comparative look at these issues. And I agree with the first two speakers that the quality of justice, be it civil or common law, depends very heavily on the quality of the court decisions that are made. This is a universal. This is an issue in Canada that we still face. I work in judicial education. We year in and year out teach 2 courses in judgment writing for judges that deal with many of the factors that have been talked about here today, because our judges are far from perfect when it comes to articulating reasons and letting the loser know, and all the parties in the court know, why it is that the court came to the decision that it did. My remarks, though, will be more focused than that. They'll deal with one aspect of this. That is where sound, clear legal provisions provide guidance for development of the law, especially in leading cases in common law, civil law jurisdictions, and in precedential type cases in common law jurisdictions. I intend to speak about those precedential cases and relate them, the common law approach, to the civilian approach, and especially with respect to employment of those approaches in apex courts or supreme courts. I note that Canada is a bijural jurisdiction. It has and applies both civil and common law, but most of my remarks are going to relate to the phenomena of precedent in common law. And in fact, common law is the predominant law that applies in Canada. Civil law is applied in Quebec, in civil cases as opposed to criminal cases in Canada. Precedent common law has a long, long history. Canada adopted these provisions from Britain many years ago, and Britain had a long tradition of developing precedent. Immediately when one says the word precedent, you think of higher courts' decisions binding those of lower courts. But as I am going to explain, it's a little more complicated than that. There are two major aspects to precedent. One is vertical precedent, and that is what I just said. Vertical precedent means that the decisions of higher courts bind those of lower courts when the facts and law are the same, loosely speaking. Horizontal precedent is another aspect of the precedential system, and that is where a court is bound by its own earlier decisions. And that's less talked about than vertical precedent, but a feature of precedent in Canada and indeed all common law countries. The principles, though, that guide the application of precedent are changing. They're changing in Canada and in other countries. We used to think of precedent as a rule. It was a rule that was applied. The leading Canadian scholar, Deborah Parks, who recently wrote another article on this topic in Canada, said, and I paraphrase rather than quote, she said she regards precedent now as more of a practice, a legal practice, than a legal rule. So the binding nature of precedent and the strict application of precedent is coming into some question. Of course, civilian systems don't have binding precedent. There are leading cases that are persuasive in civilian systems. And I would note as well that high courts in various countries go by different names. And I am going to get into court, so I wanted to make this point here. And they have, you know, their high court, I'm not going to get into the names, but there's different names for the apex courts in different countries in civilian and in common law jurisdictions. They have different powers of appeal, of revision, of cassation, and also in civil jurisdictions, constitutional courts have, of course, a unique place. But what I am going to focus on is Canada and Ukraine. And in Canada and Ukraine, we use the term Supreme Court to describe the highest court. That's the term I'm going to use in this presentation. With respect to high courts, Supreme Courts, they are the highest court, and as such occupy a unique position in Canada. The Supreme Court of Canada exercises a special place in leading the justice system. And if I understand the Ukrainian reforms correctly, that is the hoped-for position of the new Supreme Court in Ukraine. The precedent principle by which all higher court decisions bind lower court decisions can be distinguished from the general situation of the application of Supreme Court decisions to lower court decisions. So what I'm saying is the general precedential principle of the common law binds all courts in a common law system, but that can be distinguished with respect to the unique role of Supreme Courts in a common law system or in any law system. Why use precedential or leading cases? Well, I think most of us are familiar with some of these reasons. They positively guide the development of the justice system. They authoritatively articulate democratic rule of law principles and reflect national values. They define the fundamental rights of citizens. They promote uniformity of practice. They resolve conflicting cases. They promote a leadership role for Supreme Courts. And these are principles that are recognized in all systems. Now, just a short word on the history of the Supreme Court of Canada. Before 1975, the Supreme Court of Canada heard all cases that came before it where an appeal was requested. So the Supreme Court was, in effect, an error-correcting court. It had, consequently, a very heavy caseload and little time to craft the well-constructed judgments that have been talked about here with all the features that have been talked about here, reasons, demonstrating to the litigants that they've been heard, and writing a judgment in a way that is organized and can be easily understandable, easily understood even by those who aren't legally trained. And that's important for all courts, but it's particularly important for courts that purport to be issuing cases that other courts should be following, either as a matter of rule or as in common law cases, or as a matter of persuasion, as in most civil law jurisdictions. Therefore, in Canada, in 1975, largely because of the impetus of the Supreme Court of Canada, we changed the process and adopted a very robust filtering system, a leave to appeal system, by which an applicant has to submit an abbreviated application to the court, giving their reasons for why they should be heard in full by the court, and having that considered by the court. The basis for granting such an appeal, a full appeal in Canada, is basically whether the case is of national or legal importance. Merely arguing that the case was wrongly decided will not get you an appeal in the Supreme Court of Canada. That drastically reduced the number of cases that the Supreme Court of Canada had to hear. Back in 1976, it reduced them, and now 40 years later, in 2016, these are the numbers. The Supreme Court of Canada received about 500 applications for permission to appeal, the abbreviated application, and they granted full appeal in approximately 50 of those applications. So they heard 50 cases, and that permitted the Supreme Court to devote the attention to the cases that they deserved because of their precedential or leading value for other courts, and because they reached out, if I can use those words, to the citizens of Canada to demonstrate that the courts indeed understood the values of Canadian people. So filtering is necessary to create a Supreme Court as a justice system leader. In Canada, we have the leave to appeal system that I've talked about. The European Court of Human Rights, which I note is structured very much like the new Supreme Court in Ukraine, with it has 5 lower chambers and a grand chamber. 2 levels. It has, as I understand it, a very, very robust and extensive filtering system of cases that come in. The statistics that I was able to locate say that there were about 53,000 new applications in the European Court of Human Rights in 2016. A lot of those went to the lower chambers. The Grand Chamber accepted about 30 cases to be heard in that year. So without getting into the mechanics of all this, it's apparent that there's very very robust filtering mechanisms, and the same applies for various other European jurisdictions where for access to the highest court, to the apex court, there is some system to identify important cases. Precedent in Canada promotes certainty and predictability. However, critics cite rigid adherence to precedent as a factor that leads to stagnation of the law and slowness to react to changes, including new societal developments. So how have we in Canada approached this? How have we avoided this, straitjacket of precedent? Well, the Supreme Court of Canada has stated on more than one occasion that precedent must be flexible so that it's dynamic, so that the case law remains relevant to Canadians and articulates current public values. As I said, there is horizontal precedent by which higher courts, or by which courts are bound by their own decision, but that today has very, very many exceptions. And the first and most important one in Canada is that the Supreme Court of Canada has explicitly said it is not bound by its own earlier decisions. So that horizontal precedent principle doesn't operate in the Supreme Court of Canada. At the appeal court level, just below the Supreme Court, different appeal courts, there's 10 in Canada, have adopted different approaches to this, but they too have methods of reconsidering some of the decisions that they've already made that would otherwise bind them, so that they keep current, as it were. There's many reasons to consider changing earlier decisions. Again, you can't be bound forever. Society changes, and the courts have to reflect that. Science changes, and in some cases just removes the underpinnings of what seemed like a good decision at the time. So cases have to be changed. We also have vertical precedent, where decisions of higher courts bind those of lower courts. But despite that fact, there is a great flexibility in the system, and lower courts, I wouldn't say regularly, but lower courts on many occasions depart from the decisions of higher courts in precedential terms. But when they do, they have to explain why. Clearly, why are they doing that? And let me give you an example in Canada of a situation, 2 cases where this happened. In 1993, Sue Rodriguez, a woman, an ordinary woman from British Columbia, was very, very, very ill. She applied to the court for a constitutional override based on security of the person of a criminal code provision of a crime that forbade anyone, including a doctor, to assist in suicide. She wanted to die. And this case went to trial to the Appeal Court and to the Supreme Court of Canada. And the Supreme Court of Canada at that time, in 1993, issued a very extensive and full rejection of that possibility. So fast forward to 2015. Lee Carter, Ms. Lee Carter, 40 years later, took her mother to Switzerland, whose mother was very ill, for a doctor-assisted suicide. That happened. Her mother died in Switzerland. Ms. Lee returned to Canada, where she was arrested and charged with assisting suicide. And by all accounts, this case looked like the Rodriguez case of 40 years earlier. Everyone thought, well, she'll be convicted. But she wasn't. The trial court acquitted her. The Court of Appeal in British Columbia convicted her, said the trial court was wrong and should have followed Rodriguez. And the Supreme Court of Canada agreed with the trial judge and acquitted her. And how did the Supreme Court of Canada reach that decision? Well, they found that the trial judge found, and they agreed with the trial judge, that the law and legal analysis of the constitutional right guarantee to security of the person had changed fundamentally in the 40 years that had gone by. There were new social and legislative facts that pertain to this kind of a situation. And this rested, the original case had rested on a long and accepted societal abhorrence of suicide in Canada, but that had changed over the 40 years. One of the reasons in Rodriguez was the Supreme Court said it's a slippery slope. It's very dangerous to be permitting this in any form because vulnerable people, like people with mental disabilities, could be swept into this regime and involuntarily euthanized and voluntarily killed. Without getting into any more detail, they said there were safeguards in place now. There were ethical standards in place that weren't there earlier, and this changed the approach to the case. So this is an example of the dynamic use, I guess, of a precedent and how it can change even in a common law country where precedent is so important. My next slide just deals with some of the ways in which precedent can be dealt with by lawyers and trial judges who wish not to apply an earlier precedential case. And the next slide. The best held principles will not be effective unless they're well communicated and accessible. And this just echoes what's been said here earlier this morning. Writing judgments that are clear and give good reasons and are precedent worthy are absolutely fundamental to development of the law, whether it's a formal precedent or a persuasive case written by a Supreme Court. And Chief Justice Roman, you referred specifically to this. As well, accessibility, again, an obvious point, but the database that contains these decisions needs to be easily accessible to lawyers, judges, and ordinary people for it to serve the purpose that it does. My conclusion, well, common law type precedential systems by which all higher courts bind all lower courts is definitely not a legal phenomena that is going to be adopted by Ukraine. But the common law experience in precedential type or leading case decisions at the Supreme Court level especially could be of some use in assisting the development in law in Ukraine. regarding those principles. So thank you very much.
Дякую, пане Чіассон. Безперечно, що